Hello friends, welcome to my channel Steno Guru India. So ready friends, start. In the judgment of the case Sandeep Khaitan Resolution Professional for National Plywood Industries Ltd Limited versus JSVM Plywood Industries Limited and another delivered on April 22, 2021, Justice Uday Umesh Lalit and Justice K. M. Joseph at the Supreme Court have prefaced their findings in the judgment with the observation that the contours of the jurisdiction under Section 482 of the Criminal Procedure Code are far too well settled to require articulation and reiteration, while at the same time pointed out that in passing the impugned order on February 4, 2021, which is an interim order for that matter, the Guwahati High Court appears to have overlooked the salutary limits on its power under Section 482 para. According to the Supreme Court, the power under Section 482 may not be available to the High Court to countenance the breach of a statutory provision para. The words "to secure the ends of justice" in Section 482 cannot mean to overlook the undermining of a statutory dictate, which in this case is the provisions of Section 14 and 17 of the Insolvency and Bankruptcy Code 2016 (IBC para). In view of the Supreme Court having regard to the orders passed by the National Company Law Tribunal NCLT admitting the application under Section 7 and also ordering of moratorium under Section 14 of the IBC, and the orders which have been passed by the tribunal, otherwise the impugned order of the High Court resulting in the respondent number 1 JSVM Plywood being allowed to operate the account without making good the amount of rupees 32.5 lakh to be placed in the account of the corporate debtor cannot be sustained para. The court has also noted the no objection from the appellant's counsel to the respondent number 1 being permitted to operate its account subject to it remitting an amount of rupees 32.5 lakh into the account of the corporate debtor para. In this case, an applicant filed under Section 7 of the IBC was admitted on August 26, 2019. The appellant was appointed as the interim resolution professional, and what is more, a moratorium was declared. With this declaration, the prohibitions as enacted in Section 14 came into force. It is clear that the assets of the company would include the amounts lying to its credit in the bank accounts para. There is no dispute that well after the order under Section 14 was passed, a sum of rupees 32.5 lakh has been remitted into the account of respondent number 1 company. No doubt it is the definite case of the respondent number 1 company that it has had business relations with the corporate debtor since more than 15 years, and that the amount remitted in its account represented the price of the materials supplied to the corporate debtor. Apart from this amount, a sum of more than rupees 39 lakh is still due para. The SC has also noticed that though an appeal was filed against the order admitting the petition under section 7, the same was dismissed by the appellate authority of the NCLT. The appellate order of the NCLAT was set aside by the Supreme Court and the appeal was remanded to the NCLT for its consideration. On March 20, 2020, the NCLT Guwahati ordered that the appellant was at liberty to act as per law, and the words used in the earlier order of February 28, 2020 relied upon by the respondent number 1 were found to be a mere casual observation which did not culminate into any direction. Full stop. If you really love this dictation today, like and share it. Don't forget to subscribe Steno Karo India to receive wonderful dictation. Thank you.